Can you state your name for the record and spell your last name?
Juliana Nanarone, Nannarone.
Do you swear or affirm that you will interpret accurately and impartially, follow all guidelines for court interpreting that are binding on you, and discharge all of the solemn duties and obligations of an official interpreter?
I do.
Thank you.
Counsel, your appearance.
Good morning, Your Honor. Judson Hanley, Assistant Prosecutor. Speak.
Judge Heather Timmons, Office of the Public Defender. Judge, it's my understanding that Mr. Barrios has been approached on 3 separate occasions to complete a 5A and has not done so. There has been some issue with, I believe, the dialect of Spanish that he speaks. I am not sure if he understands, and I'm happy to do his detention, but I need to know that he wants to have the services of the public defender.
Mr. Barrios, good morning. Have you understood everything our interpreter said so far?
I don't know. Your Honor, the interpreter believes that the defendant might not speak Spanish. There are many other, languages in Spanish-speaking countries that are not related to Spanish at all.
Mr. Barrios, do you speak a specific dialect of Spanish?
¿Habla usted un dialecto específico del español? Yes.
What?
¿Qué es lo que usted habla? ¿Cómo se llama? Could the interpreter ask Mr. Barrios what language he speaks?
Yes.
That's okay. ¿Cuál idioma habla usted? ¿Cuál es su idioma materno? ¿Qué idioma habla usted? The interpreter and Mr. Barrios are not understanding each other at all.
Somehow he gave a statement to the police. So,
Well, Judge, with
do you want
respect,
to ask him his home country? No, I mean, do you want to ask him?
I can, Judge, but with respect to the statement, the investigator in my office who speaks Spanish reviewed the statement for me, and it was his opinion that Mr. Barrios did not really understand what was being said to him in the room, and at one point someone is speaking English to him, and he's nodding, but it's very clear that he doesn't really understand.
This is a video?
This is a video statement, yes.
Thank you. Counsel may have your appearance.
Good morning, Your Honor. Venus Desai for the state. Jackie Boulos on behalf of Mr. Juan Chavez-Amaya, and they were arraigned the last time we were here.
And Judge Heather Timmons for Jorge Barrios.
And before we begin, there is a presumption of detention in this case.
That's correct, Judge.
All right. State.
Judge, as it pertains to probable cause, the state has provided initial discovery, which includes numerous statements, including the statements of both defendants, although I do acknowledge that many of the statements are in Spanish. So I have not myself even personally been able to listen to all of them yet, as well as relevant surveillance video, photographs, and the affidavit of probable cause.
Does the video capture the incident?
It does not. The video that's been turned over captures these 2 defendants and the victim earlier together, which is sort of how the investigation played out, specifically, primarily as it pertains to Mr. Chavez-Amaya, who is caught wearing, on surveillance video, with very distinctive jeans that we now have found soaked in blood that were disposed of. So as it pertains to the probable cause, Judge, the relevant facts are that these 2 defendants and the victim were at an abandoned house on Welton Street. The 2 defendants have given slightly differing versions of what happened and how. What, however, is undisputed is that they struck the victim with what I think has been described as a stick, but also physically described as something consistent with like a 2x4. and that he was struck repeatedly. The crime scene photos also seem to bear out that there's blood on the wall of the basement where the body is found, where it looks like his head may have been struck against the wall as well. And there are what appear to be wounds to his face and head, which could be consistent with being struck with a 2x4. But Mr. Barrios in his statement indicates that Mr. Chavez-Amaya indicated he stabbed the victim as well in the face. The victim did die of blunt force trauma to the head, and the cause of death and manner. I'm sorry.
Could you repeat that the victim did die?
The autopsy revealed they died of blunt force trauma to the head. According to both defendants, they specifically, Mr. Chavez-Amaya says specifically that the victim was still breathing when they left. He was left in the basement, and the two individuals just departed for the evening. Judge, just to sort of fill out what the version that Mr. Chavez-Amaya claims is that he claims that the victim was the aggressor. He indicates that the victim had a knife and that he felt he was protecting himself. I do note that a small knife was recovered, but it was recovered in the inside of the victim's pocket. I have not personally seen what the knife looks like, but it was not recovered anywhere near the outside of the body. I believe it was recovered inside of a pocket.
I'm sorry. I believe it was recovered.
Inside of the pocket. Where the stories diverge, Mr. Barrios indicates that he observed Mr. Chavez-Amaya repeatedly strike the victim, that he heard noises from the basement and went down, and that he indicates he only struck the victim once and then asked Mr. Chavez-Amaya to stop. Mr. Chavez-Amaya indicates that they both struck the victim several times. I should also note, Judge, I believe Mr. Chavez-Amaya was spoken to 4 times before we got to this version, and Mr. Barrios twice. Initially, they both, Mr. Chavez-Amaya initially denied any involvement, and Mr. Barrios initially placed all the blame on Mr. Chavez.
Mr. Barrios said.
Mr. Barrios initially placed all the blame on Mr. Chavez-Amaya. What we did recover, Judge, during talking to Mr. Chavez-Amaya, officers observed blood on his sneakers, as well as a shirt that he was wearing. Initially, he indicated to them that it was his own blood. We did recover those items. They've been sent for DNA testing. At this point, I have a verbal representation that one of the samples on the sneakers, I believe there's 3, but one of them is a single source profile with the victim's blood, and that the T-shirt is a mixture with the victim and the defendant, Mr. Chavez-Amaya's blood. Mr. Barrios also took police to the location where he indicated he saw Mr. Chavez-Amaya remove his pants, which Mr. Chavez-Amaya told police a different version of what had happened to them initially. Those pants were recovered, field tested positive for blood, and DNA testing is pending on those. Mr. Chavez-Amaya, during his statement, did acknowledge that the blood was from the assault on the victim, that he had attempted to wash his clothes, and that he did, in fact, take off his jeans when he got a new pair of pants and discarded of them accordingly. So, Judge, based upon those facts, I believe that there's probable cause as it pertains to the murder. The complaint is split up in 2 counts, but they're charged in the murder count as well as an accomplice count, since it appears that they acted in concert. And they are also charged with leaving an endangered victim based upon the representations that he appeared to be breathing when they left. So, Judge, I do believe that the statement has met its burden on probable cause.
As the probable cause.
Thank you, Judge. Judge, first, I do want to predicate similar as to what the state said, that a number of the statements, I think there are 24 discs, and
I'm sorry.
there are 24 discs, and a number of them are in Spanish. And I did the best I could with the short time frame we had was not able to review and translate in time all of the statements, so I would reserve any right to return on this matter at a later date as the discovery unfolds what is in those statements. That being said, what we have in front of us today, based upon the reports that summarize those statements, I would submit to the court that they do put forward a potential self-defense claim for Mr. Chavez-Amaya.
Could the officer possibly turn the volume down on the radio?
They do support a possible self-defense claim on behalf of Mr. Chavez-Amaya. This is clearly not an identity case, but a culpability case. Both Mr. Chavez-Amaya as well as Mr. Barrios indicate that the alleged victim in this case struck first, and that there was a knife involved. And in fact, as you heard from the state, the knife was recovered. The fact that it was in his pocket does not alter the fact, as is indicated by Mr. Barrios in his statement, that after that initial scuffle with the victim, Mr. Chavez-Amaya leaves to go get what he indicates as a stick to defend himself against the man with a knife. So that would not necessarily negate the fact that the victim may have put the knife in his pocket at this point. That being said, Judge, I would submit on probable cause and reserve my arguments for detention.
Judge, as to Mr. Barrios, the affidavit of probable cause indicates that during his second statement, he admitted that he struck the victim with an object. Given the short time frame that we do have, I did have my Spanish-speaking investigator review that statement. It's over 2.5 hours long. What the report that he sent to me via text, in the interest of time, is that he had listened to the entire interrogation and that he never makes any admission. In fact, he blames the killing on the co-defendant. And it appears that as he struggled here in court, he struggled to understand and answer the questions during the interrogation. So given that this is a summary of what my client allegedly said during that statement, perhaps if there is some place that we're missing, the state could point us to where my client makes this alleged admission. Because according to my investigator, there is no admission by Mr. Barrios as having struck the victim in this case.
Ms. Timmons, can I just ask a question? If it's just, there's two statements Mr. Barrios gives. It's in the second statement.
This was the second statement. Yes. This was the. I believe the first statement was 4 hours. If the time was accurate on the screen, which I did not ask him to review because the statement indicated it was the second one, so this was marked as the second statement of Mr. Barrios. Judge, so with that, I do not believe that the state has met its burden with respect to the murder. Again, I was not able to review Mr. Chavez-Amaya's statement. I know there's some indication that he allegedly said that Mr. Barrios struck the victim. I don't know where these objects are and how many there were alleged to have been. But it appears perhaps there was one and Mr. Chavez-Amaya had it, and that he did in fact strike this victim on that date. He has the blood on his clothing, he has the blood on his t-shirt, on his pants, on his shoes, and there's nothing to indicate that Mr. Barrios had any sort of blood or any indication that he had been involved in this altercation that day.
Thank you. with regard to probable cause, there must be a showing of some evidence of the offenses, or at least a reasonable suspicion of the crime. If I give Ms. Timmons the benefit of the argument that Mr. Barrios does not implicate himself, allegedly the co-defendant does, and there's video of him in the area, and if I'm not mistaken, there's blood on both the clothing.
Judge, and I didn't address this part because it's going to be part of my detention argument. The clothes we believe Mr. Barrios was wearing on the date of the murder have not been recovered.
Just Mr.
Just the clothes that Mr.
Chavez-Amaya.
Chavez-Amaya was wearing. Correct.
The issue is the strength of the state's case with regard to probable cause at this point. The court finds it respect to Mr. Chavez-Amaya based on the statement, the video, and his clothing. As to Mr. Barrios, I'm not sure what's on the video statement, but the co-defendant does put him at the scene and allegedly involves him in the striking of the victim with an object, possibly a piece of wood or a 2x4. My recollection of the probable cause is that the statement, Mr. Barrios puts him at the scene, but not committing any offense.
So, Judge, and I'm trying to get an answer as to where my understanding is that Mr. Barrios' admission was towards the end of the second statement.
Okay.
What he indicated, as represented to me, and again, I haven't reviewed the Spanish statement, but I was awake and on the phone with the officers as this was happening in terms of being able to do the charges later. My understanding is that he admitted to lightly tapping, I think almost like what we would refer to as like a love tap. He indicated he lightly tapped the victim. It's my understanding that he acknowledged doing so with, again, another stick. But he denied striking him more than the one time. He further indicated during that statement that he did stay there while Mr. Chavez-Amaya went back upstairs to retrieve something, and that when Mr. Chavez-Amaya came downstairs and continued to strike the victim, that he told him to stop. So he does minimize his own involvement, and what he indicates is that he lightly tapped or struck him. Obviously I don't know the exact words. Mr. Chavez-Amaya says that they both struck him, I believe it's 3 to 4 times. So that's where the divergence is in terms of the statements.
And Mr. Chavez-Amaya's statement, that's in Spanish as well, I take it?
Yes, Judge.
Have you heard that statement?
Judge, I listened to parts of the statements, and again, in a similar situation as counsel with trying to get somebody to help interpret along with my Spanish is decent, but not good enough to understand the statements. So much of what I'm relaying to you, Judge, as Your Honor knows, that when we're on call, in terms of us making charging decisions, information is relayed to us temporaneously. So part of the reason one of the statements is, I think, 4 hours is they left at some point, called me, we had a discussion, so that there are gaps in the statements as well. So I was kind of being kept abreast as things went. I'm sorry. So I was being kept abreast as things were developing. But much of what I'm telling the court comes from what was relayed to me from the officers.
So for the record, so it's clear, with respect to probable cause of Mr. Barrios, the court's relying on the statement of the co-defendant at this time for probable cause. I say that because in the event, which may be up to 6 hours of statement, if the defense finds that that's inaccurate, then that may affect the court's ruling on probable cause with respect to Mr. Barrios.
Judge, I can provide a little bit of guidance. The detective indicates to me that it was at least an hour and a half into the statement, and that it would be at a portion when Detective Brown was out of the room, and it was just the two Brunswick officers in the room.
Statement 2.
Statement 2, correct, towards the end, and it would have been towards when Detective Brown was out of the room, and Detective DiMarcella and another new Spanish-speaking officer were in the room. So maybe that'll help sort of guide where it is.
Judge, my understanding is he reviewed the entire statement, and at some point, someone is in the room speaking English to Mr. Barrios, and no one is translating. So the way it was relayed to me is that there are a lot of affirmative answers, but there's no indication that Mr. Barrios understands what is being said to him.
Okay.
But I understand for purposes of probable cause where we are, Judge, but I'm sure this will be an ongoing review.
Right, and I understand, Judge. I'm just trying to, in terms of the issue that was brought up to me, it's also my understanding visually he makes a demonstration. I'm sorry. It's my understanding that when watching it, there's a visual demonstration where he indicates what he means by tapping. So that, again, would probably home in where in the statement we're relying on.
Did we swear him? Oh, it looks like we're... The court finds probable cause with regard to Mr. Barrios based on the co-defendant's implication of Mr. Barrios in the striking, and with regard to Mr. Chavez-Amaya for the other reasons, including his statement, as well as the bloodied clothing that was discovered, and the statement of Mr. Barrios as it relates to Mr. Chavez-Amaya. Okay. Next step. Presumption.
Judge, I think the presumption shifts, so burden of the defense first.
I agree with the state. Judge, the burden does rely on the defense at this point. Mr. Chavez-Amaya, Judge, has been in this country for many years at this point. He resides locally and has ties to the community. If he were to be released, he would be residing at 15 Kempton Avenue in New Brunswick with a friend of his named Alexander. Judge, as you can see, he has no prior contacts with the law. And again, he lives locally. He has been around here. There's no attempts for him to flee at this point. He has met with officers multiple times, clearly been compliant with orders from officers. No indication that he would attempt to obstruct the process, given his cooperative nature with officers, even though there are multiple statements, and I understand the state may argue that it took multiple statements from him for hours, Judge, but obviously given the nature of this case, I don't think it would have resulted any differently, and I don't think that detracts from the fact that he willingly was there with officers compliant, giving these lengthy statements. And again, Judge, just reiterating a part of my probable cause argument, it does appear in the videos that they were together earlier. A witness statement also indicates that they were all drinking. Clearly, alcohol is involved in this incident, and some indication that the victim had a weapon when all of this went down in that home. So I would argue, Judge, that these are circumstances that are unlikely to recur were he to be returned to the community, and that the court could find some combination of conditions to release him at this time. Thank you, Judge.
Thank you, Ms. Timmons.
Judge, as to Mr. Barrios, he also has been in this country for the last 7 years. He is employed. And Judge, while I don't presume to know what happened that particular evening, there does seem to be significant question as to Mr. Barrios' involvement. I would note that he did give a statement. He gave 2 statements. And although my Spanish is non-existent, it appears that from the very beginning of this case, Mr. Barrios has been trying to tell anyone who would listen that he did not strike this individual, that he did not kill this individual, and that it was, in fact, Mr. Chavez-Amaya. In addition to that, Judge, the reason that the state is in possession of the clothing is because Mr. Barrios led them to the clothing. There was a search warrant based upon the information that Mr. Barrios had provided. So he has been extremely cooperative in this case, Judge. And again, his culpability, and hopefully as we get a chance to review the discovery further, we'll be able to at least get a sense of what we believe happened in this case. But from all accounts, it does not appear, well, let me take that back. From his account, it does not appear that he struck this victim. And the only indication to that would be the co-defendant, and I'm not sure in which hour of his 6 to 8 hour statement he decided to implicate Mr. Barrios. Just so based on that, which my argument is the strength of the state's case against Mr. Barrios, I do believe that there is a combination of conditions that can satisfy the statute. And I ask Your Honor to set those conditions and release Mr. Barrios.
Mr. Barrios is a 4-3 on the PSA scale.
Correct, Judge.
And there's some, I'm sorry, I didn't know you argued.
I was just going to say, Judge, I didn't know if you went.
Feel free to jump in when I do that. I apologize.
So, Judge, in terms of both of them, I acknowledge that the PSA scores are low. Mr. Chavez-Amaya is actually a 1-1. And Mr. Barrios is a 4-3. I suspect because there are disorderly persons, violent type offenses that are pending or out there. And he does have a failure to appear in municipal court from, I believe last year it was. So, Judge, if I could start with, and I'll address both in terms of the fact that the state doesn't believe that they have stable addresses to go to. I'll deal with that first. In the statement Mr. Chavez-Amaya initially gives, and the information we initially learn, is that this Welton Street address that the victim is found in is an abandoned house that these 3 individuals, along with other friends of theirs, used to stay in. The upstairs portion of the house is where they use, I think there's some makeshift beds and things like that where they can stay. The basement, unfortunately, is used as a restroom. That's where the body's found. The house is boarded up. They enter through a back door that has to stay unlocked. They only lock it when they're inside because they obviously don't have a key. They are, from our investigation, both individuals do some day labor work on occasion. There is no steady jobs as far as we have uncovered during the investigation, nor a steady address. In fact, Mr. Chavez-Amaya goes further and describes for the police that there's actually 2 houses they stay at. There's one on Welton Street, and sometimes they stay, I think the other one is on Comstock Street. And his initial version to police is that he, Mr. Barrios, and the victim are drinking at the Welton Street address, that the victim leaves to go get more beer because he had just been paid $400 for work he did, that when he didn't come back for 30 minutes, him and Mr. Barrios left, walked around town, couldn't find him, and then went to the Comstock Street address to spend the night. And I'd have to go back and double check the name, the Kempton Street address that Mr. Chavez-Amaya indicates he can go to was actually a location that was searched, unless there's another second house. where a friend has indicated that he will allow Mr. Chavez-Amaya to keep clothes, come in to shower, and the like, but it is by no means a permanent address. And at least my understanding of the initial information from him was that he wasn't really permitted to stay there. He might let him crash once in a while. So unless that's something that's changed, it's certainly not a permanent address from my perspective. As it pertains to Mr. Chavez-Amaya, Judge, and specifically the state's concern in terms of obstructing the process and the risk of flight, without stable addresses, stable employment, and some sort of stability to tie them to this community, that's obviously a concern. More importantly, as you've already heard me tell the court, this defendant went out of his way, admitted to washing his clothes to get rid of the blood, admitted, and we recovered, that he discarded the jeans he was wearing because of the amount of blood on them. Both defendants indicated that the weapon, whatever it was, stick, 2x4, whether it was one weapon or two, were discarded. The victim's cell phone was taken and has not been recovered. The knife Mr. Chavez-Amaya allegedly used has not been recovered. And as I indicated earlier, initially Mr. Chavez-Amaya made it seem like this was his friend, that nothing had happened, and he didn't have any involvement in it. And it wasn't until Mr. Barrios led us to the jeans that that changed. So, Judge, in terms of the detention factors, the risk that the defendant will obstruct the process is incredibly strong, as is the risk that the defendant will not appear in court based upon the actions he took to cover up his tracks in this particular case. And certainly, Judge, when they leave a man who they claim to be a friend for whatever purpose in a basement that's used as a restroom to die, I think that poses a danger to the community. As it pertains to Mr. Barrios, Judge, again, his score is higher, and I do note that there is, although I don't believe there are any convictions, I believe they're all pending. There are 2 simple assault charges, one from October of 2017, and one even further back than that, May of 2015, that are pending. So certainly there is some history of violence in Mr. Barrios' past. And again, this defendant has no stable address or job that we're aware of. In fact, it took detectives over a week to even find Mr. Barrios. Admittedly, Mr. Chavez-Amaya was able to be found much easier, but it took them a long time to even track Mr. Barrios down because of the nature of the way that these individuals live and move from one house to another. That certainly makes it more difficult. And as it pertains to Mr. Barrios, Judge, we still don't know where the clothes he wore on that day are, and whether they would bear out blood or his involvement in the attack. He isn't able to provide a decent explanation for where they are. Mr. Chavez-Amaya says that he saw Mr. Barrios ball up his jeans as well, but doesn't know where they went. But those clothes have not been recovered. And again, same thing with the weapons and the cell phone that have not been recovered as well. So certainly there's already been attempts to obstruct justice in that regard. And again, the same arguments, Judge, in terms of the way the victim was left behind. I would submit to Your Honor that there are no combinations of factors in this particular case that would substantiate release, especially when the presumption in these particular matters is in favor of detention.
With regard to the nature of the offense, the defendants are charged with first-degree murder and accomplice liability. As to the strength of the state's case, the court finds it, in weighing it, significant as against both parties. Lesser so, however, with regard to Mr. Barrios, but nevertheless a strong case as well. All three individuals apparently were together at some point. And it appears that the defendants may be claiming self-defense. The victim's knife was in his pocket when his body was recovered. And at one point, one of the defendants leaves the scene of the assault and returns. There were attempts by Mr. Chavez-Amaya to hide and discard his clothing, an attempt to cover up his participation. If the court were to weigh the factors, the offense itself carries 25 years to life. The strength of the state's case is strong. There's a recommendation of detention or a presumption of detention. In weighing the benefits to the defendant, if any, I'm constrained to the fact that they live in the area. There apparently is no secured employment nor housing. The housing at the time was an abandoned house. I understand the argument that they voluntarily met with the police, but initially there was the denial. I also understand the argument regarding Mr. Barrios that he provided the police with the location of the clothing of the co-defendant. That may be because he was willing to implicate the co-defendant. It may also be he was trying to curry favor with the police since they did not have his clothing at the time. Nevertheless, the co-defendant implicates him in the offense and his involvement. Whether or not there's an admission by him, I give no weight to that at this point. But I am satisfied, based on the presumption, as well as the other factors, including the risk of flight, in light of the fact that neither have an address at the time of the offense, together with all the other factors, I find that no set of conditions can reasonably assure their return to court, and more significantly, the safety of the community. So I am going to order detention on both at this time. Mr. Chavez-Amaya and Mr. Barrios, this means that you're going to be detained until this matter is resolved. Starting today, you have 7 days to appeal this decision. Also, the state has to indict you within 90 days. If they fail to do so, you can be released. And once you're indicted, they must try your case within 180 days. You have a court date on May 10th with Judge Nieves. Thank you both, counsel.